2021, a 5-judge bench of the High Court made a decision which, in our humble view, is one of the most extensively reasoned and groundbreaking decision in the entire history of our country's constitutional jurisprudence. It is that decision that the appellants now ask this Honorable Court to overturn, citing an array of grounds. My lords, my ladies, we humbly submit that the consolidated appeals be dismissed in their entirety with costs to the respondents, and the decision of the Superior Court be upheld and affirmed for the grounds that we submit herein below. My lords, my ladies, all the appellants view that the so-called Building Bridges initiative was a popular initiative. With tremendous respect, we strongly disagree. Instead, we agree with the Superior Court that this was not a popular initiative. It was it was a presidential initiative or executive initiative, which is not provided for in our Constitution, and the attempt subsequently by the initiative's promoters to rope in the people at the tail end of the process to sanitize their illegal and unconstitutional venture must spectacularly fall on the facts and the evidence. On the issue of the character of a popular initiative, we make 2 arguments. The first is that we agree with the Superior Court that this illegal process to amend the Constitution of Kenya was initiated by the President of the Republic of Kenya in his official rather than private capacity. We say so for these reasons. 1, the fingerprints and footprints of the President of the Republic are strewn and splattered all over this heinous affront on the Constitution of our country. My lords, my ladies, secondly, the President created a task force, after which he created a steering committee to implement the recommendations of that task force. And the mandate of that steering committee was clearly stated in paragraph B to include making or proposing legal, administrative, and even constitutional changes. Thirdly, on that point, is that the President established both the task force and the steering committee via the Kenya Gazette. It is our submission, my lords, my ladies, that the Kenya Gazette is not a newsletter, it's not a newspaper, it is not a pamphlet, nor is it a private publication. It is the official publication of the government of the Republic of Kenya, and for that reason, the President, in appointing these institutions, was acting in official capacity, which is our first argument. Further, to cement that argument, the steering committee so established generated a report, And attached to that report was a bill to amend the Constitution, which bill is the subject matter of this litigation. And it is the bill upon which the signatures, which are in contention here, were collected. The fingerprints of the president and his footprints are also evidenced by this, that the submission of the task force report to the president, the submission of the steering committee report to the president, the launch of the collection of signatures exercise, and all other events associated with this ill-fated exercise or process were presided over by the President of the Republic of Kenya using state machinery, and none of these meetings or events took place in anybody's private home. My lords and my ladies, it is our further submission that the reports of the task force on the same point and the report of the steering committee were addressed officially, and I quote, to, open quote, His Excellency, the President of the Republic of Kenya and Commander-in-Chief of the Defense Forces, the Honorable Uhuru Kenyatta, comma, CGH, end of quote. Further, it is not controverted that the collection of signatures for this cause was aided to some extent by public officials, chiefs, and other public officials within the executive arm of the executive, which the president presides over. At no point in the whole exercise did the president relinquish his tools of official functions, as was ably cited by my learned friend, Mr. Mutuma, the ASA presidency in 2014, during the International Criminal Court cases. And I am privileged to have been one of the defense counsel in the Kenyan cases at the International Criminal Court. And when it came to the hearing of that court and the initial appearance, the president of the country downed the tools of power openly and publicly and signed a deed, in which deed he appointed his deputy for approximately 60 hours or thereabout to act as president of the country so that he could attend to what he termed a private and personal matter as a private citizen, Mr. Uhuru Muigai Kenyatta. My lords and my ladies, on the second argument on that point, we submit the President of the Republic of Kenya has no right to initiate a popular initiative. Why? Because this avenue of popular initiative is reserved for private citizens, including civil society, and is not available to state officers or state organs. The learned judges in the Superior Court took time to explain that the historical context of Article 257 on popular initiative, according to the Bomas report, was the history, the checkered history of Kenya with constitutional amendments. And therefore, it was clear that citizens wanted an avenue where they can amend the constitution and force government to legislate things that they think government through the organs of state does not wish or is not ready to legislate. How then can the same government, which is supposed to be compelled to legislate by the people through a popular initiative, be the same government using that avenue. And therefore, we agree with the learned judges of the Superior Court that there were other avenues available to the head of state and the president to initiate whatever amendments he wanted to do. First, under Article 132 of the Constitution, the Cabinet may make proposals to, for legislative proposals. The Cabinet can do that. Also, the Attorney General under Article 156 of the Constitution normally aids the President in bringing government legislation. And under this Constitution, particularly, the office of the Leader of Majority in the National Assembly and the Leader of Majority in the Senate is actually the avenue through which government bills and legislation proposals are channeled. And I speak that with some little authority by virtue of my previous background outside the premises of what we are dealing with today. That therefore this was the wrong avenue for the President to use, and he had other avenues to use. Secondly, on the same point, the second reason why we say that this route is not available to the President of the Republic of Kenya is because, as it was found in the Superior Court, that there was no evidence tabled to provide that the President had used other avenues available to him and failed. On the second thematic area of public participation, which my learned colleague Geronimo has submitted, I just want to add the following comments. First, I was somewhat surprised when Learned Senior Counsel Otiende Amolo yesterday, or is it the day before, submitted before this court, tried to demonstrate how it is it's impossible for all the steps of public participation identified by the learned judges in the Superior Court for public participation if we are to allow Wanjiku to be the one to drive the popular initiative. We disagree with that view because, and I heard Senior Counsel Otiende Amolo exemplify and ask the court to reflect on whether, for example, Wanjiku can have the bill published, I don't know, in the national languages, the national language, which is Kiswahili, the official languages, which is English and Kiswahili, the vernacular or indigenous languages, and so forth and so on. And he said if we submit Wanjiku to this kind of procedures, it will not have been possible, and I hope I'm not misquoting Learned Senior Counsel. Our view is that this demand, this 10-step process demand, was not the invention of the learned judges in the Superior Court. It is a dictate, a requirement of the Constitution in Article 7 of the Constitution, which the learned judges relied on, which calls on state organs and state processes to, for example, use the languages and even try to promote indigenous languages and the use even of Kenya Sign Language and Braille where possible. And when it comes to the technical side around Braille and Kenya Sign Language, the Constitution is considerate and uses such terms as promote as opposed to demanding outrightly that that must be done. And therefore, on this public participation, it is a demand of the Constitution. Secondly, on the same theme, it is our submission that both the popular initiative and the parliamentary initiative must therefore adhere to what the learned judges provided for the 10 steps of public participation. There was very little public participation in the processes that were taken up to this point before this litigation arose. For example, the example was given of Siaya, which passed the bill upon receipt. Siaya, in their wisdom, the Assembly in Siaya County, in their wisdom, decided to pass this bill within 24 hours. I don't know whether they did the public participation at midnight or at 3 a.m. and what methods they applied. Within a day or two, they had passed it. Tana River attempted to do the same, but the County Assembly of Tana River was stopped on their tracks, and their action, which had already taken place, was nullified by Chepunyi J, sitting in Garsen, where he said that you cannot submit a bill, a process of enacting such a fundamental bill amending the Constitution and process it in microwave time. In fact, that is the term. You'll see that when you retire in the authority which my learned colleague Gerono cited. It's called Abe, like Abe Shinzo, Abe Brere. Abe Brere, I hope I'm not mispronouncing, Abe Brere versus the Speaker of the County Assembly of Tana River and two others. And the judge said, don't even take what you have passed to Senate or even National Assembly. And the thing died. But because the promoters had already had their kill, they had enough majority, so they proceeded, notwithstanding that they didn't have Tana River County Assembly on board. And my Lord, why are we emphasizing this? It's because there is a reason why the Constitution demands that the bill be submitted in Article 257, the bill be submitted to the county assemblies for 90 days. The county assemblies have 90 days to process the bill. There's a reason, and that reason is public participation, among others. I say so because I had also the submissions yesterday by learned counsel, Mr. Gumbo, who told this court that in a different issue of signature verification, the regulations demanded that IBC should take 14 days. But in the wisdom of IBC, they decided to shorten that process to 5 days, which included a Sunday, which is normally not computed in terms of time. And therefore making the whole issue of statutory timelines a laughing stock. I am afraid to submit that